So the medical bills, talk about that in some detail. Medical bills, and even if you have a claim that's strictly medical only, a lot of employers will try to pay those on their own, and it's probably not a great idea to do that because you as an employer will oftentimes just simply pay the full amount of the bill. If you submit that bill to your insurance carrier, it's a med only claim. The insurance company has a bill review process where they'll go down and reduce those bills. They have agreements with certain health insurance organizations, bill review services that will go through and essentially, let's call it, knock the fat out of it and pay what's actually owed, which can be significantly less than the bill that's actually presented to you as the employer. So it's really a good idea to turn it in. And in fact, Wisconsin really does not penalize employers very much, if at all, on what we call med-only claims. These are also referred to as no loss time claims. So Wisconsin doesn't treat those too harshly. It really benefits you to turn those in. In Wisconsin, the employee traveling back and forth for medical treatment, they are paid their mileage for that. And it's usually based upon the current IRS rates that are whatever they are in a particular year. That's what is paid out. The other thing to understand about the medical bills is that HIPAA, which is the Health Insurance Privacy Protection Act, which we're all pretty much aware of one way or the other, is a federal law meant to protect your privacy, but it specifically excludes workers' comp. But you have to still be very, very careful with it because oftentimes when medical records get sent from an employer, or if you have to call, or if you as an employer have to call the doctor's office up to get clarification on restrictions, you be careful that any non-work comp medical issues are really segregated from the work comp issues, because you can inadvertently run afoul of HIPAA because of some other medical condition that has nothing to do with the work comp injury. So HIPAA does not apply, but you still have to have your antenna up and be very careful of how you're sending information. Safest bet is if you get medical information, only communicate that with either a nurse case manager that's on the file or the work comp company, the insurance company that's handling the claim. Be careful about anything else. So just watch out for that. Question comes up, in the state of Wisconsin, can an employer or an insurer direct care of an employee? And the answer in Wisconsin is big no. Other states allow it to some extent or completely. Again, depends on the state, but Wisconsin essentially says no. Now, that doesn't mean that you as an employer or the insurance company have no recourse. The employee has essentially the first and second choice of a Wisconsin licensed healthcare provider. And that could be a physician, psychologist, chiropractor, dentist, physician assistant, advanced practice nurse prescriber, or podiatrist. So they get the first and second choice. But the employee has to notify you of the second choice if they decide to go to somebody else. Now, in an emergency situation, it's perfectly fine to get the employee to the nearest facility. But after that, once the emergency situation's over, the employee really gets to choose their treating physician after that. And again, this does not mean you as the employer have no recourse or your insurance company has no recourse. There's a whole system set up to deal where the insurance company can have an independent medical exam to determine if the treatment is reasonable and in line with what's expected per American Medical Association guidelines and question it. So you can question it. And also, if you look at DWD Chapter 81, treatment guidelines, there are certain guidelines in there that are built in by the agency to limit certain types of treatment.